please your lordships, I appear with Mr Singler KC and Mr White, and the class representative, the respondent, is represented by Mr Venkatasan KC and Mr Semester. As the court will have seen, Meta is appealing against the decision of the Competition Appeal Tribunal to permit the class representative to amend its pleading to introduce a claim for user damages in these proceedings. And it's common ground between the parties that the test on an application to amend is the same as the test on a strikeout or a summary judgment application. So the question is, does the class representative's claim for user damages have a real prospect of success? We say that it does not, and we make two related submissions. The first is that this court is bound by the Court of Appeal's judgments in Was and Devonish to find that user damages are not available for breach of competition law. And the second is that that conclusion is consistent with the later authorities, in particular the Supreme Court's judgment in One Step v. Morris Garner. And One Step, we say, establishes that user damages are available for proprietary torts and are not available in tort more generally, and it is consistent with Was. And indeed, as I'll show you, the Supreme Court considered Was and did not overrule it. Now let me, if I may, identify what we say is an important point up front concerning the rationale for an award of user damages. An award of user damages is an exception to the general rule in tort that damages should place the claimant in the position they would have been in absent the tort. And as we will see in One Step, and indeed consistently in the case law, the rationale for an award of user damages in respect of certain torts is that the tort creates or protects a property right by providing that it is a wrong for anyone to take or use that property without consent. And an award of user damages is made in recognition of the fact that this right has not been respected and that the claimant has thereby lost the opportunity to control their property or to negotiate any fee for its use. So in that sense, an award of user damages might be described as normative in character. It reflects the fact that the wrong has been committed rather than compensating the claimant for any counterfactual consequences. And we say that the proprietary torts and the adjacent tort of misuse of private information all have this in common. So the tort in each case confers or protects a right to property or to private information, and the wrong is committed when the property or private information is taken or used without consent. And user damages are available to reflect that wrong, even if there is no counterfactual loss. And we say that competition law is wholly different. It does not protect anyone's right to property or to any valuable asset. What it does is imposes a regulatory duty on undertakings not to distort competition in the market by engaging in certain conduct. And class members are unable, we say, to point to competition law to say, well, these rules give me an exclusive right to property, and if anybody invades that right, I'm entitled to damages whether or not I've suffered pecuniary loss. That's not the function of the competition rules at all. Nor, a fortiori, do the competition rules confer any property on any individual not to have their property used without their consent, which is the essence of the proprietary torts. And indeed, as I'll show you in a moment, there is no allegation in this case that Meta has used class members' information without any consent. On the contrary, class members have contracted with Meta to allow Meta to access their data. The complaint of class members is about the terms of that contract. And so with that introduction, my lords, I propose to make my submissions as follows. So I'll take your lordships briefly to the class representative's pleading to show you that at its highest, the allegation here is about the terms of the agreement between class members and Facebook. I'll then explain why we say this court is bound by Was and Devonish to find that there is no arguable claim for user damages in competition law. I'll then explain why this is consistent with the later authorities, including One Step, and as I go along, I will address the key points made by the class representative in her skeleton argument. So, starting with the context in which this appeal arises, you'll have seen from the skeleton arguments that the claim concerns what the class representative has called off-Facebook data. And this is data relating to the activities of class members on other sites, so for example, merchants' websites. And the class representative's complaint relates to the terms on which Facebook agreed with class members that it would provide them with the Facebook social media service in return for them granting Facebook access to and use of their off-Facebook data. So if I could ask you to pick up the supplementary bundle, tab 12. This is the re-amended claim form, which begins on page 199. And there is a summary section you may have seen at the beginning of the claim form, and I can make the points I wish to make by reference to the summary section because it's consistent with the main body of the pleading. And if we take it from page 203 of the bundle, you can see the heading there, abuse, paragraph S13. So the abuse is summarised like this: by making access to its platform contingent on users giving up access to their off-Facebook data without a corresponding value transfer to users, Facebook infringed the Chapter 2 prohibition. As a matter of legal classification, the abuse in the present case can be looked at in two related ways that in practice amount to the same thing. The first is that Facebook imposed unfair terms and conditions. The second is that Facebook imposed an unfair price. In both cases, the gravamen is the unfair bargain or barter Facebook made with users, and ask you to underline, at least mentally, those words. It's the unfair bargain or barter. And this, for the court's reference, corresponds to paragraph 150 in the main body of the pleading. And then we see in the next paragraph, paragraph S14, the heading, side heading, imposition of an unfair trading condition. And you see a reference here to what's called, what the class representative calls the take it or leave it condition. And essentially, the complaint is that users were given no choice to avoid or limit the collection of off-Facebook data if they wanted the social networking service. And then if we turn over the page, please, to if we go on a couple of pages to page 205, can I just ask the court to read, can I ask you to read to yourselves paragraphs S16 and S17, which are under the side heading imposition of an unfair price. If you could just read those two paragraphs to yourselves. So the unfair price, so even though Facebook did not charge users for the service it was providing, the price is said to be unfair because it said that either you could see Facebook was able to demand an unfairly high price or payment in kind, that's use of the Facebook data for the provision of social networking services, or it offered an unfairly low price for users of Facebook data. So that's how the unfair price allegation is put. And you can see that it's said to be the other side of the coin of the unfair term allegation. So the two go hand in hand. And we saw earlier that it was said to be, in practice, amount to the same thing. That's what they say at paragraph S13. Now, pausing here, as I've said, there is an important distinction between the allegations in this case and the cases in which user damages are held to be available.
Can we look at 19 as well, just to make sure we understand the basis upon which they're saying both abuse and loss?
Yes.
S19 operates upon the premise that the abuse, the unfairness, is to be measured by reference to what would have happened in a competitive counterfactual market.
Yes.
And that's exactly the same way as they analyse the loss. That's how they plead the loss and damage.
That's right, although they then plead, I'm going to take you in a minute to the parts of the pleading that make the allegation about loss in respect of the proposed user damages claim.
But you accept that their basic premise for both abuse and compensation is what would have happened in a counterfactual, sufficiently effective market?
I do. So just pausing here and before going on to the next parts of the pleading, as I've said, we say that there is an important distinction between this case and the cases in which user damages have been held to be available in tort. The purpose of the proprietary torts is to provide a cause of action if expropriation or invasion or use of property without consent occurs. The same is true of what I'm going to call the adjacent tort of misuse of private information. Those torts are not concerned with the situation where a person has struck a bargain with someone else, allowing them to use their property, but then complains that the terms of the bargain are unfair. This case, by contrast, is a case in which the complaint is about the terms of the bargain, as you've seen. There has been no invasion of property rights or expropriation of property without consent. On the contrary, and assuming for these purposes that off-Facebook data is equivalent to property, so let's assume that for the moment in the class representative's favour, class members have agreed with Facebook that Facebook can access and use their data. Their complaint, as we've seen, is that the bargain is unfair. They say that in terms in paragraph S13. Now, if we turn back to the pleading at page 208, under the heading loss and damage, you can see here that there is going back to my Lord Justice Green's point, the first part of that paragraph explains the basis for the conventional claim, if I can put it that way, for loss. And it requires a comparison between the actual and the counterfactual. And then you see the second part of the paragraph says, and or prevented from exercising their valuable right to control the collection and or use of their off-Facebook data. They have therefore suffered compensatory loss in the form of conventional loss and or, two, the loss of a valuable opportunity to exercise the right to control the collection and or use of their off-Facebook data. Now, you can then see at paragraph 25, so you can see in paragraph 25, the final sentence, this is the conventional loss allegation. The outcome of that counterfactual, so in the counterfactual, absent the abuse, Facebook would have been obliged not to impose unfair terms and or prices and would have been obliged to negotiate a fair bargain or barter with users. The outcome of that counterfactual bargain would have resulted in a monetary payment by Facebook to users. So that's the way that the allegation of conventional loss.
And it's the would have there, would have because of the law, not because of what. And the law just simply says it imposes a price which it says is fair in all the circumstances in the counterfactual, and it compares that with the price which was actually paid.
Well, it's comparing the price that was actually paid. So the counterfactual, you strip out the infringement. What's said is that Facebook imposed an unfair price, and then they say that that's abusive, you strip out the infringement, and they say in the counterfactual, then Facebook would have had to have paid users for their data. And the way
a fair non-exploitative price.
Yes, and the way that you get at that is by constructing a hypothetical negotiation.
And I know in your amended defence you say in the counterfactual Meta wouldn't have, and we want to query that, because is it a question of what Meta says it would or would not have done, or is it just something the law imposes? The law decides. As you know, we've been dealing with all these excessive pricing cases where the law says X is what would happen in a counterfactual competitive market. You've charged Y. The abuse is the difference between X and Y. It's the law that imposes, not about what Meta subjectively would or wouldn't have done.
Well, my lord, it's both, we respectfully say, for this reason. So if one's got a straightforward case where one is, for example, selling a pharmaceutical product, and so in the counterfactual, that same product would have been sold, and the allegation is that in the real world it's been sold at an excessive price, then you're right to say that there's then, in a sense, the fact that in the counterfactual this product would have been sold is almost taken for granted in those cases. And the question is, what does the law say is a fair price? So you're right. This case is more complex because in this case, the question is, what would the arrangements have been in the counterfactual? Now, of course, the court doesn't have to accept what Meta says the arrangements would have been. It has to make a factual finding on the basis of all of the evidence. But in the counterfactual, it may well be that the arrangements would have been completely different, such that the law did not require Meta to pay a price which the law considers is a fair price. So that there are two steps to the analysis. Factually, what would Meta have done? Would all the facts have been the same, such that Meta was providing the social networking service on the same terms, in which case you're right that the law then establishes what the fair price would have been? Or would the arrangements have been different? So if they're right, if the class representative is right about the abuse, would Meta have adopted different arrangements? And what will be seen at trial is that post this period, Meta has adopted different arrangements which don't involve paying consumers anything for their data. So to put it another way, the court will have to decide whether there is a whether there is a non-abusive and likely counterfactual that doesn't involve Meta paying a price. So it's not, with respect, as simple as saying the law imposes a counterfactual.
So is your point that if the counterfactual is one in which Meta would have paid for this information because it wanted it and it had to compete for it?
Yes.
That's governed by the existing cause, the existing pleading. That's your point, is it?
Yes.
Because
exactly.
then the court, the tribunal, needs to determine what that price would have been.
Exactly, my lord, yes.
But so, what other arrangements wouldn't have involved that? Just to give an example of an arrangement wouldn't have led to that.
Well, let me see if I can give you an example that's more than just hypothetical. So, for example, it could be that that consumers are given an opportunity to pay a fee in return for not receiving personal advertisements, and in those circumstances their data would not be used. So there are different commercial arrangements that Meta could put in place that we would say are perfectly lawful, that don't involve paying consumers for their data.
They haven't in the past. I mean, this is a historical claim for damages where you have actual conduct, not hypothecated theoretical conduct.
Yes, but you've got to compare the actual conduct with the likely counterfactual. So there will be a debate at trial about the likely counterfactual, and it can't be assumed that the counterfactual is keeping the facts exactly the same, but paying consumers an amount.
Can you assume that the pharmaceutical company wouldn't have sold those drugs, but would have sold some other drugs?
That may be a point in a case. So that if that point were raised by a defendant, so if the point were raised, well, in the counterfactual where we couldn't charge this price, we would have ditched the product totally. That is a point that could be raised in any case, of course.
You're identifying issues which are for trial.
For trial. They're not for now, but I'm just responding to the court's questions.
But I mean, an issue you'll have to grapple with is that you've now identified things which could affect the scope and effect of the claim for both compensatory damages and user damages, which are, on your case, complicated issues for trial.
My lord, with respect, no. So our case is a straightforward point of law that as a matter of law, user damages are not available in competition cases. And I haven't got to my submissions on that yet, but we say that that doesn't turn on any facts at trial about the counterfactual. That's a pure point of law. And we say, moreover, that not only did the tribunal fail to identify any facts that might be determined at trial that bear upon that legal issue, but the class representative herself, in her skeleton argument, has failed to identify any facts that might emerge at trial that bear upon that pure issue of law.
One of the things we'll need your assistance with is that at the moment, on one view, the pleading is just bog standard competition law damages. Meta did X, in the counterfactual where the abuse didn't arise, they would have done Y. We've got to monetize the consideration passing both ways, and that's the measure of damages.
Well, apart from the user damages amendment.
Well, but depends, why is that user damages? What is it about the pleading which you say means there's user damages, and how do you define user damages? Because on one view, this is absolutely classic Devonish. And Devonish, the first instance where they held that compensatory damages of this sort are recoverable.
My lord, let me just show you, can we go back to the pleading?
Yeah.
So looking at paragraph S24.
Yeah.
So Facebook's breaches of statutory duty have caused loss and damage to the class. As a result of the abusively unfair bargain or barter made by Facebook with UK users, class members were, one, not adequately compensated for the economic value of their off-Facebook data collected and monetised by Facebook, for which Facebook would have paid in the counterfactual, which resulted from the abusive conduct.
So do you accept that's classic compensatory
Classic
damages?
compensation. So we've got to distinguish between the two allegations. And or two...
But if they win on that, isn't that the end of it?
Yeah, they are plead. Yes, if they win on that, then they get their damages. What they're seeking to do in this case, and this is really the issue before the court, is add in a claim for user damages. Presumably, if they don't win on that, they're going to say, well, that doesn't matter, we've got our claim for user damages. And there is a clear distinction in the pleading. Our application is our application before the tribunal. Sorry, it wasn't our application. What we were doing before the tribunal was resisting the class representative's application to add the claim for user damages. And let me show you
That was because you had then said in the counterfactual,
no,
we wouldn't. I mean, it seemed to have been...
No, my lord, nothing to do with the counterfactual. So we accept that all of the points about the counterfactual, so counterfactual loss, are for trial. So we're not seeking to strike out in any way the conventional claim for damages, which was always there. So all of that is for trial, we accept that. But what they've done, and let me just show you on the pleading, and then I'll come back and make my submissions on it.
Okay, so what we want to know is, if they lose on that, so the court says there is no compensatory damage available, which was the opposite of what the court said in Devonish, because they held there that explicitly the restitutionary and the compensatory damages were the same, and therefore the analysis proceeded upon the basis that compensatory damages were adequate, and therefore did you need restitutionary damages?
I'm going to come to... I'm not going to accept what you say, my lord, about Devonish, and so I'm going to come to Devonish separately.
Okay.
But going back to the pleading, what they say is we're entitled to conventional damages, so counterfactual damages in respect of pecuniary loss. All of that is for trial. We've got arguments about the counterfactual, all for trial.
Of course.
But what they're seeking to do is add in a different claim for user damages. And if we go back to paragraph 24, so I read the first bit up to the end of Little Roman 1. Then we have Little Roman 2, and or prevented from exercising their valuable right to control the collection and or use of Facebook data. That's the addition to reflect, that picks up on language in user damages claims to say that there's been this separate thing which is preventing users from exercising their valuable right to control the collection. We'll see that language in the case law on user damages. they have therefore suffered compensatory loss in the form of conventional loss. We're not touching that, so that's all for trial. And or 2, the loss of a valuable opportunity to exercise the right to control the collection and or use of their Facebook data. That's a plea for user damages. And then, just pausing here, if we then go to paragraph 25, you see in the counterfactual, Facebook would have been obliged not to impose unfair terms and prices, would have been obliged to negotiate a fair bargain. The outcome of that counterfactual bargain would have resulted in a monetary payment by Facebook to users. That's all conventional loss, right? We're not quibbling with that for these purposes. And then you have at 26A, further or alternatively, it nevertheless wrongfully interfered with the user's valuable right to control the collection and or use of their Facebook data. That being so, the users are to be compensated for the loss of the value of the exercise of that right. So that's compensation for user damages. That loss can be quantified by the use of the Nash bargaining model to assess the outcome of a hypothetical negotiation between Facebook and users.
And that would, by definition, be in a counterfactual. It's a hypothetical. As I understand the Nash model, it's essentially... I wasn't certain when I was trying to determine what that meant, how different, if at all, it was from the ordinary process of determining what would happen in a competitive counterfactual.
So they're using the Nash bargaining model as a means of valuing the loss of the right to control their data, which is
Agreed. But the methodology was a hypothetical bargain, which would be under conditions of effective competition.
And one of the points that we make about...
Am I wrong in that?
No, I think you're not wrong in that, but you have to distinguish between the theoretical or the basis for loss in each case. So the basis for conventional loss is asking yourself, that's a conventional approach to tort. So you're saying, absent the tort, you're trying to put the claimant in the position he would have been in or she would have been in, absent if the tort hadn't taken place. So you're asking yourself, what's the counterfactual loss? User damages is different. So user damages can be given where there's no counterfactual loss at all. So where you've got land which somebody has trespassed on, you may suffer no loss at all as compared with the counterfactual.
Yeah.
But what you're claiming for are user damages, reflecting the fact that you've lost control of the property, and that control, you've lost the opportunity to negotiate a fee.
Classic damages for breach of a patent, where you're not in competition with the infringer because you're therefore not in the same market, and therefore you wouldn't have recouped those money anyway. I understand
exactly.
That. But I mean, we were just trying to understand how the Nash principle is any different to a counterfactual of determining what the prices would have been in a competitive market.
My lord, it may not be, but that's in a sense, it's a point in my favour, because what it shows is that although the case law, as we will come to see, says that the important thing about user damages is that they're not discretionary, so the court can't just award them if it finds that conventional damages haven't been suffered or can't be calculated. They can only be awarded if there's a proper theoretical underpinning justifying the award. And the fact that the class representative in this case is basically putting forward a theoretical bargaining model for both shows that in fact she's treating user damages as something there to just fill in the gap. If we don't win on the first type of damage, we win on the second.
We wonder whether this is really user damages. You know, it's just another way of putting ordinary compensatory damages.
The claim is said to be a claim for user damages.
But the first question would be identifying the counterfactual rate. That's the first step.
Not for a claim for user damages. So,
but in a competition claim.
In a competition
this isn't
claim.
A claim for damages. User damages as such. It's a claim. It's a competition claim.
Yes.
The first step is to identify the counterfactual.
Correct.
Is your fear that if you establish at trial the counterfactual is one in which Facebook customers, potential customers, are given the choice? You either have this where you give us all your off Facebook data, or you don't. But if you don't, you've got to pay us for it. And if that is the true counterfactual, is your concern that in that situation there would then be a claim for user damages?
Yes, so, my lord,
But wouldn't, and it could be said, your counterfactual would be an answer to both ways of putting it.
My lord, if it's an answer to both, then that's all well and good, but I don't respectfully consider that the class representative Wood's case is that it's an answer to both. So that just stepping back and thinking about first principles, it may be that we can see this more easily when we look at the cases, but every competition case up till now has proceeded on the basis that damages are available for what I'm going to call counterfactual loss. What the class representative is saying here is that even if we don't suffer, even if we can't show that there's been any counterfactual loss, we nonetheless have a right to compensation to compensate us for the fact that our data has been used. That's how it's put. And that's
I wonder if this is, I mean, we'll get clarification. I wonder if it is how it's put, because tracking through the pleading to see what was actually meant by Nash damages, since it does operate upon, it's just a different way of describing the counterfactual, this hypothetical bargain or negotiation, what would have happened in terms of effective competition. If they lose on A, they're going to lose on B. Well, so is that really just, are they really saying this is user damage, or was just another way of calculating compensatory loss?
Yes, so so the key distinction between conventional and user damages is the factual issue of whether or not Meta would have made a payment. So if Meta would not, in the counterfactual, have made a payment, they can't show any pecuniary loss, and we say that's the end of it.
But that would be the same on both the
No.
25, 26 and 26.
No, that's not their case. So
isn't it?
No. They say, and that's why we're all here. If it were their case, we'd be delighted, frankly, but that's not their case. Their case is that even if they can't show any counterfactual loss, any pecuniary loss, they nonetheless have a right, by analogy with proprietary torts, to an amount of money. So leave aside the counterfactual. Even if we're right on all of that, they have a right to an amount of money based on the fact that in the real world, their data was used by Facebook. That's and the way it's calculated, my lord, is by reference to this model, which then includes consideration of the counterfactual. That's the calculation of it. That's their methodology for calculating it. And you see in the case law that where user damages are awarded, the courts do often proceed on the basis of a hypothetical negotiation. So it might be said that that does involve counterfactual issues to that extent. But the availability of the award doesn't depend on showing that counterfactual loss occurred. So that's the distinction.
So assuming you're correct, and that's the way the CR puts the case, this appeal turns upon whether or not the case law is closed or open for debate.
The appeal turns on two things: whether you're bound by Devonish and Wass, and we say you are, and whether or not on the cases, leaving aside Devonish and Wass, and applying the recent authorities one step and so on, whether they have a reasonable prospect of success of establishing a claim for user damages. And we say that is a point of law which doesn't depend on facts that might emerge at trial. Nobody's suggested it does, apart from the tribunal that said it in the most vague way without actually identifying any facts that might emerge at trial. It's a pure point of law, and this court should grapple with it. So those are our submissions in a nutshell.
The tribunal's answer was that they needed to determine whether or not compensatory damages were available.
And that's an error. And my lord, I'll show you why that's an error, because the court says in one step, the Supreme Court says that that's not the basis for user damages. You can't simply say, oh, well, we'll have an award of user damages if compensatory damages are not available. So that was a clear error in the tribunal's reasoning. And it didn't identify, neither has the class representative identified any factual circumstances that might arise at trial that will have a bearing on this pure point of law.
So the starting premise for this appeal is that Meta has engaged in an abuse in that its terms and conditions are unfair and exploitative in terms of the value passing between the parties. And yet you would say that no loss arises, and therefore there is no remedy for what the tribunal ex hypothesise found to be an unfair and exploitative abuse of terms and conditions. What remedy does apply then?
No, so we say that if the class representative succeeds in establishing at trial, which I accept as a matter for trial and not for now, that Meta has acted in an abusive way by charging an unfair price and imposing unfair terms, the question is, as it is in every competition case, did that cause the class members to suffer loss? And that involves a comparison between the factual and the counterfactual. It's all for trial. It may or may not result in a loss, but what we say is impermissible is the additional amendment which says even if it didn't result in a loss as compared with the counterfactual, we're still entitled to damages because you used our data. That's the point that we say is not arguable in law.
So in 26A, is it really the words or alternatively which you object to?
Let me just go back to that, sorry. So well, it's further, or it's the whole thing. So we say further, I mean, it's the whole, it's not just alternatively, it's whether or not it's available at all. So
it's contradistinct to 25, which is premised on in the counterfactual.
Precisely.
But your point is 26A on its face is not suggesting it arises because of any counterfactual analysis at all.
Precisely, and they've said this is a claim for user damages, and the whole point about user damages is that they are awarded even where there's no counterfactual loss. That's their whole point. And we say that's what you can't have. It's not arguable in a case like this. That's the point of law.
I understand your point. I'm just looking at the words of 26A, and you're like boats passing in the night. I mean, they say, that being so, the users are to be compensated for the loss of the value of the exercise. The loss can be quantified by reference to the Nash bargaining model, which, as we all agree, is based upon a counterfactual.
Well, we don't need to go into the methodology of the Nash bargaining model. What they're doing is, as they say here, it's assessing the outcome of a hypothetical negotiation, which is what the cases on user damages often do. They say, well, how do we quantify this normative loss? I'm going to call it a normative loss because it's not a loss of in any counterfactual sense. It arises because of the invasion of property rights and the loss of an opportunity to control them. And the way the way damages are often calculated in the user damages cases is by means of a hypothetical negotiation. But it's important in our submission, otherwise this would be underselling my learned friend's case. It's important not to conflate the fact that the proxy or mechanism for calculating those damages, that may involve some degree of hypothetical counterfactual consideration, but that is not relevant to the premise for the award of damages, which is that they are awarded even where there is no counterfactual loss. And that's really why they've pleaded.
I mean, I understand the theory. I find the circularity of it, oddity, 26A, since, as I understand Nash, it's based upon a counterfactual, which is not dissimilar to that which you'd use for compensatory damages. Well, it's not really saying if there's no value at all, we get damages. They're saying, another way of looking at this, we get damages if we can prove that in a hypothetical competitive market.
No, that's not their case. They are saying, even if there's no counterfactual loss, we get damages to reflect the loss of control of the data. And then how you go about calculating it is another question.
So the premise you say, one way of dealing with this is to start with the premise that their case is, if there is no loss on an ordinary compensatory counterfactual basis, they can nonetheless apply for a quantification based upon a hypothetical negotiation.
Yes, to reflect loss of
control.
Control, exactly. That's the basis. That's the premise for this whole appeal. That's what they're seeking.
The only difference between the two hypothetical negotiations seems to be that in the user damages version, you exclude the possibility that Meta won't play ball.
Sorry, I didn't hear that.
You exclude the possibility that Meta won't play ball.
Yes.
That's the only difference.
I think that is a difference. I'm not sure it's the only difference. Yes, I think that's the key factor. So we don't accept that the methodology is exactly the same, but that is the key factor. I think that's a key difference. And so, but in a sense, it's not. submission, and I think we are going to be on common ground with the class representative as far as this is concerned. Their amendment to make a claim for user damages, they would say stands. So they would say an award for user damages should be made, even if class members have not suffered any loss in a counterfactual sense. And then the way in which that's calculated is according to this hypothetical bargaining model, but the conceptual premise is that the award is made even though no counterfactual loss has been suffered. And that's what we're objecting to, because we say that that sort of award is given in, that's an exception to the general way in which tort law proceeds, and it's an exception which is confined, as it does not apply in competition cases, and not in this case. That's what I'm going to come on to next.
I just wonder what the basis of the claim is, because it's a competition law claim.
Yes.
Nothing else at the moment.
Nothing else.
But I'm wondering if we ever get to this point, because in order to establish any right for damages under competition law, they're going to have to establish that in the counterfactual they would have been entitled to receive something.
Yes, that is a fundamental point. That's one of the points we make.
That's why I must repeat the question. If they can't establish that as a matter of competition law, and if they can establish that, then you're into, well, it's the existing pleading.
Exactly.
You just work out what the price would have been.
Exactly.
If they can't establish that, what claim is left? They haven't got a freestanding claim for damages for interference with property rights.
My Lord, that's exactly our point in a nutshell. So we say that there is no freestanding claim for any breach of any property right. And what you have, user damages are awarded precisely where there is a freestanding claim for breach of a property right, for use of property without consent. That's why they're awarded in the law of trespass, detinue, conversion. Here, there is no freestanding, and also I should say for misuse of private information, which is adjacent to those proprietary torts, because that tort directly confers and protects a right not to have your private information used without consent. Here, there is no freestanding claim. They've only got a competition claim, and the way that they try and get round that is to say, oh, well, the facts are similar to the kinds of cases where the proprietary torts arise, but that's not good enough, and that, in a nutshell, is our answer to this amendment. So I'm not going to stop there, but that is the single most important point that we make. And
can you just show, you say they plead that the facts are similar to the kinds of cases where proprietary torts
let me show
arise.
you.
Is that in the pleading?
Let me show you their skeleton argument. So
it's in the skeleton, not the pleading.
Yes, it's in the skeleton, not the pleading. The pleading, what the pleading does is tries to pick up on the words that you get in user damages cases about loss of control, sticks them in the pleading.
If they hadn't used the words user damages in 27...
No, but that is what they... I mean, we're all agreed that that's what they're after.
If I was just looking at 26A, I'm not certain I would have... The expression user damages would come into my mind as a description of what's being sought here.
Yes. Yes, and so, but my Lord, just going back to looking at the S25 and S26 in the pleading, that's all about but-for loss.
Yeah.
So you can see that, 26, in short, but-for, that's all about counterfactual loss. And 26A is different. So 26A is saying, leave aside but-for counterfactual loss. This is about loss of control of the data. And if you go to their skeleton arguments, that's in core bundle tab 10, we go to paragraphs 85 and 86 on page 134 of the bundle. So paragraph 85, they say, in fact, let's take it a bit earlier than that. So if we go to page 133, you see the heading, the CR's positive case for user damages.
Sorry, page?
133. So this is tab 10 of the core bundle. It's my learned friend skeleton argument.
Yeah.
And you can see that at 84, the class representative's case is that wrongdoing of the kind described above, so that's the pleaded wrongdoing, is materially indistinguishable from wrongdoing for which user damages are currently available, namely the wrongful use of property where the claimant has a right to control the asset. And then over the page at 85, there's only one distinction between this case and the category of case identified above in which user damages are available. The distinction is that what made the use of the asset wrongful in this case is a statutory provision, whereas what made it wrongful in the category of case identified above is a common law rule. But that's not the only distinction. The more fundamental distinction is the one identified by my Lord Justice Zacaroli, which is that the competition rules don't confer any right to property at all.
But it's not quite that, it's that the Act doesn't make this wrongful unless this is an advantage that couldn't have been attained in a situation of workable competition, i.e. you've always got to have regard to the counterfactual.
Correct.
Have I got that wrong?
Exactly, no, you've got that completely right. And then if we go to paragraph 16 and 17 of their skeleton argument.
Sorry, can I just ask another question? Looking at the pleading, I know Mr. Singler will get excited about this one. The jurisdiction of the CAD would not, I think, extend to dealing with a pure tortious claim for compensation, unless it's a breach of Chapter 1 or Chapter 2.
Correct, and certainly you couldn't bring, exactly, so that's the first and fundamental point. And secondly, of course, you can't have a collective action unless it's for breach of Chapter 1 and Chapter 2.
But the CAT will have to, there's a lot of work the CAT's got to do to get to this stage. But if it comes to the conclusion there is no compensable loss at all, it may say, well, regardless of whether or not you could have brought a claim for tortious damages based on user damages in the High Court, not something we can deal with.
Well, there's that point, but more fundamentally, the statute just does not envisage an award of user damages because breach of competition law is inherently, if I can put it this way, a counterfactual tort. It's a regulatory duty not to distort the market.
It's not exclusively. I mean, for example, exclusionary damages. I mean, in lots of cases, you're looking at what would have happened in a hypothetical where the abuse or the cartel hadn't existed.
Yes.
There are some cases, for example, vertical exclusion, where it may not be quite the same.
Well, my lord, I think it is, in the sense that you're still stripping out the infringement and saying,
You're always saying stripping out the infringement, yes.
But here you're not for user damages. That's really the key point. And if you look, can I just show you paragraph 16 and 17 of their skeleton?
What would happen if we came to the conclusion that whatever they said in the skeleton, their pleading in 26A was still a counterfactual analysis and neither added to nor subtracted to what was in 25?
Well, then it doesn't serve any purpose. So we say it shouldn't be. It would just confuse the matter because that's not how they see it. Like if you look at paragraph 16, can I just show you their skeleton? So page 113. As to causation and loss, the CR's case is that absent the abuse in question, Meta would have had to offer a fair bargain to users, and that any such fair bargain would have resulted in a value transfer to them. One of Meta's defences is that even if the abuse is established, users should not receive any compensation because Meta would not have been willing to pay anything for the data that it ex hypothesi wrongfully took and used. Obviously, that will need to be determined by the court as to whether that's a likely and lawful counterfactual. However, if, as the CR contends, user damages are available, that defence falls away. This is because the fact that the parties would not actually have negotiated a licence, or D would not actually have made a payment to C, is irrelevant to an award of user damages. This reflects the nature of user damages. They constitute compensation for the economic value of the right which has been breached, considered as an asset. So pausing there, 2 points. Crystal clear from this that what they're trying to do in their pleading, what they're intending in their pleading, is to introduce a claim for user damages that doesn't depend on counterfactual loss. And secondly, it's interesting to see that there is agreement between us as to the rationale for user damages. If you look at the quoted words there, user damages constitute compensation for the economic value of the right which has been infringed. Well, what's the right that's been infringed here? It's competition. It's that right not to be subject to anti-competitive conduct. There is no right to property or right not to have your property invaded, such as you have with the proprietary torts or with misuse of private information. And that's really the key deficiency in their pleading. That's why user damages are not available in law. So, my lord, going back to your point, if in fact all they mean is counterfactual loss, they do not need that amendment, and it should not be permitted, because it's just apt to introduce confusion.
If the Nash principle of determining what a negotiation or barter would have been is admissible evidence to determine what would have happened in a counterfactual, or would you say that was inadmissible, or do you accept that, however it's described here, if we're just talking about the evidence which might go to the existence or otherwise of abuse, it doesn't matter to whose?
Well, my lord, that's putting the cart before the horse, in the sense that they say we are, under our user damages claim, entitled to damages even if there's no counterfactual loss, and PS, this is how we're going to quantify it by use of a Nash model. And we say, no, you're not entitled to that as a matter of principle. And the fact that they may be using...
I understand, I get that, absolutely get that. My problem is the circularity of 26A, which takes you back to a hypothetical counterfactual in which they suddenly discover there is some loss, because in the hypothetical there would have been a negotiation, and so the tribunal may say, well, what happens if the tribunal says it's very, very difficult to work out whether you're right, Meta, as to your negotiating stance, we've looked at all the evidence, we've seen what's happened in the past, and actually a hypothetical negotiation might actually be yet just another piece of evidence we throw into the mix to decide what would have happened in the counterfactual.
My lord, can I just try and identify with respect where I think you've gone wrong in what you've just said? So you say
clearly without respect.
You say suddenly discover there's a loss because in the hypothetical there would have been a negotiation. That's not their case. They're not saying in the hypothetical there would have been a negotiation.
But they're talking about a hypothetical negotiation.
As a proxy, as a means for calculating loss.
Yes.
Even if there would have been no payment in the counterfactual.
Well, they may just lose on that because it's hard to see how the two are different, but who knows? I take that point. I mean, it's not what Meta would have done. It's a hypothetical construct.
Well, my lord, it goes. If their point was, we're only if Mr. Venkatasan were prepared to stand up now and say, our case is only that we are or our case is the four corners of our case is that we are entitled to compensation for counterfactual loss, i.e. if we can show that in the real world, as compared with the counterfactual, consumers, the class members have suffered loss, we wouldn't be here. That's not their position.
So the hypothesis, taking it further, is that Meta would have done something different, it would have resulted in no identifiable loss, there would still be a finding of unfair exploitative conduct, and the remedy, the CAT would say, for competition law infringements would be a Nash bargaining model.
Well, my lord, when you say there would have been, we have to just unpick that a little bit. So their point is, the hypothesis is, Meta would have done something different, correct?
As you say, yes.
It would have resulted in no identifiable loss, correct?
Yeah.
There would still be a finding of unfair exploitative conduct. Well, we say how, because if, as compared with the counterfactual, consumers haven't been damaged.
But we're only in this appeal if you're wrong on that. If you're right on that, then this case falls away, doesn't it?
No, this comes back, I think, to the point that Lord Justice Zacaroli made to me, which is that what competition law is getting at, it's requiring undertakings not to exploit consumers, this bit of it anyway, is not to exploit consumers by acting in an anti-competitive way. And you work out whether that has happened by comparing the actual with the counterfactual. That's the whole basis on which competition law works. And they say, well, it doesn't matter about that. Let's say we lose on that. You've still used our data and we're entitled to damages for that. And we say no, because that's not what competition law provides. That's really the nub of this whole appeal.
Can I just... So let's take what you just said.
Yeah.
In those circumstances, if you establish no abuse, then you win.
We do.
And so the first part of the counterfactual analysis helps you on abuse. It's very relevant to it. So if you're right on that, then this case collapses anyway.
Well, yes, but they say not. So they say no.
Well,
because they say, well, you've had our data because these terms were abused. Their case becomes very circular. The reason for that is because competition law is not designed to protect to confer property rights, or
it may then, if that's the case, it may then come down to whether the CAT even has jurisdiction. If there's no abuse, then it's the point we had in Microsoft, which judgment is awaited. But the issue then is, what is the CAT's jurisdiction? Can it deal with things which are not competition law?
well,
Because I mean, if you're right there, and they then say, even if there's no abuse, we can still suffer.
they don't say there's no abuse. So they say, the way they put it is to say there's been an unfair price and unfair terms.
Yeah.
Even if we can't show counterfactual loss, because in the counterfactual, Meta would have had different arrangements that didn't involve a payment, that's still abusive, and we're entitled to user damages because you've kept our data. And we say that's just not how competition law works. That's really our point. But it may be that the best way of making these points good is to turn to the case law, and unless you have any further questions at this stage. But just to kind of summarise where we're at and what I'm going to say about the cases, we say that the distinction between the alleged wrongdoing in this case and the wrongdoing that would give rise in, say, a proprietary tort to an award of user damages, distinction is that the proprietary torts themselves preclude wrongful use of property, and competition law doesn't. Competition law is doing something else entirely. And also, the proprietary torts preclude wrongful use of property without consent. They're not concerned with use which has been agreed, but at terms on terms that the claimant disagrees with or considers unfair. So these are the two key points of distinction. And I was going to turn to our first submission, which is that the court is bound by Devonish to find that user damages are not available in competition claims. Or perhaps to put the point more precisely, we say that the court is bound by the Court of Appeal in Devonish's interpretation of the ratio of Stoke City Council and WAS. And before going to both of those judgments, can I summarise what we take from them before I turn them up? So WAS was a case about user damages, and the Court of Appeal held in that case that user damages were not available in a claim for levying a rival market. And in reaching that conclusion, the court explained that user damages were an exception to the general rules relating to compensation in tort. And the court held that user damages are not available in a claim for levying a rival market because the exception of user damages is only applicable in the case of proprietary torts and infringement of patents. So that's what we say WAS held. Now, Devonish was a competition damages case, and the claimant sought a restitutionary award. They didn't seek user damages, and this is a point my learned friend emphasises. And the Court of Appeal held that it was bound by WAS to find that a restitutionary remedy is not available for breach of competition law. And we say, and this is fundamental to our argument, that there are two stages analytically, logically, to the Court of Appeal's reasoning in Devonish. The first stage was that the Court of Appeal held that the ratio of WAS was that user damages are only available in tort for the proprietary torts and infringement of patents. And the second stage was the court held that it followed from that a restitutionary award was only available in tort for the proprietary torts and IP infringements and was not accordingly available for breach of competition law. And the basis, or the link, the basis for that second step was that the court proceeded on the basis that user damages were restitutionary in nature. So in other words, WAS was a case about user damages. The court said WAS finds that they're only available in the proprietary torts. It therefore follows that a restitutionary award is not available in competition law. And that second stage, that link, was because the court proceeded on the basis that user damages were restitutionary, and we now know, and that's the Supreme Court in one step has clarified, that they're not, that they're in fact compensatory. And so that, in a sense, affects the second stage of the court's reasoning, but it doesn't affect the first step in the court's reasoning, the finding that WAS finds that user damages are only available for the proprietary torts and patent infringements. And it's that stage which matters for the purposes of our appeal. So that's, in a nutshell, what we say about these cases. I'll now take you to the cases themselves. So WAS is in the core authorities, or rather authorities bundle 1, tab 6. And it was a damages action arising from an alleged fringe of a local council's right to hold a market. And at first instance, the judge concluded that the council's right had been infringed, and although no conventional damage had been sustained, the judge went on to award damages calculated by reference to the licence fee that the council could have reasonably required for the operation of the market, i.e. user damages. And the judge's conclusion that the council was entitled to user damages was overturned by the Court of Appeal, as we'll see. Now, the first judgment is that of Lord Justice Norse. And if we pick it up, please, at page 86 of the bundle. So bottom of the page, next to letters G and H, the judge identifies two general rules in tort. So you can see the general rule is that a successful plaintiff in an action in tort recovers damages equivalent to the loss which he has suffered, no more and no less. If he suffered no loss, the most he can recover are nominal damages. Second general rule is that where the plaintiff has suffered loss to his property or some proprietary right, he recovers damages equivalent to the diminution in value of the property or right. So in each case, it's counterfactual loss. The authorities establish that both these rules are subject to exceptions. These must be closely examined to see whether a further exception ought to be made in this case. And then you see that the first exception is in trespass to land. And you see that it originated in the way leave cases. And then at the top of the next page, although the value of his land had not been diminished by the trespass, the plaintiff recovered damages equivalent to what he would have received if it had been paid for a way leave. And then the second exception we see by letter E is in detenue, so wrongful detention of another's goods. And that's even if there's no counterfactual loss, there's an award reflecting loss of control of the property. And you can see in the citation a bit further down, in other words, the defendant must pay what the plaintiff would have obtained if the defendant had lawfully been in possession. And then the third exception, if we go to the next page, 88 of the bundle, we can see by letter D, third exception is infringements of patents. And you then see at the bottom at letter H, to these exceptions to the general rules in tort must be added the decision in Ruton Park. Now, pausing here, what these three exceptions have in common is that the torts of trespass and detenue and the law of patents all recognise rights over property and protect the property against unlawful use. And so when these rights are infringed, there is that the law recognises that that damages are available, user damages are available, because the owner has lost the right to charge for use of his property. And that's so even if in the counterfactual he wouldn't have charged for it. And then if we go on to page 89 of the bundle, 1413, at at 1413 of the report at letter F, you see that the same approach to root and park and the same approach as in the proprietary torts was recognised in the context of the assessment of damages awarded in lieu of an injunction. And then at letter H, Lord Justice North says this: as I understand these authorities, their broad effect is this. In cases of trespass to land and patent infringement, and in some cases of detenue and nuisance, the court will award damages in accordance with what Nichols LJ has aptly termed the user principle. On an analogous principle, in a case where there was a breach of a restrictive covenant, the court has, in lieu of a permanent mandatory injunction, awarded damages equivalent to the sum which the plaintiffs might reasonably have demanded for a relaxation of the covenant. But it's only in the last mentioned case and in the trespass cases that damages have been awarded in accordance with either principle without proof of loss to the plaintiff. In all other cases, the plaintiff having established his loss, the real question has not been whether substantial damages should be awarded at all, but whether they should be assessed in accordance with the user principle or by reference to the diminution in value of the property or right. So, now, then if we go forward, so then immediately after that, at letter B, Lord Justice North asks the question whether user damages are available where an unlawful rival market has caused no loss to the market owner. And then you see at letters, he then seeks to understand, he then seeks to apply the authorities to work out whether an award of user damages, whether the rationale for them applies in this market's case. And you can see at letters G to H, he says, it seems to me that the trespass cases really depend on the fact that the defendant's use of the plaintiff's land deprives the plaintiff of any opportunity of using it himself. And even on the assumption, which may be correct, that the broad view of Denning LJ and the Strand Electric case is a correct view of the law, the same can be said of an unlawful detention of the plaintiff's chattel. So, on the one hand, you have detenue and trespass. You're depriving the claimant of any use of their property. On the other hand, he says, an unlawful use of the plaintiff's right to hold his own market does not deprive him of the opportunity of holding one himself. And so he finds that the rationale for user damages don't apply in this case. And then if you go over the page, between letters C and D, he says, I think that if the user principle were to be applied here, there would be an equal difficulty in distinguishing other cases of more common occurrence, particularly in nuisance. And then he says, the application of that principle to such cases would not only give a right to substantial damages where no loss had been suffered, but would revolutionise the tort of nuisance by making it unnecessary to prove loss. Moreover, if the principle were to be applied in nuisance, why not in other torts where the defendant's wrong can work to his own profit, for example, in defamation? And so he then says at F, these considerations have led me to conclude that the user principle ought not to be applied to the infringement of a right to hold a market where no loss has been suffered by the market owner. Now, we then see that Lord Justice Mann, in fact, we don't see that to the end, but I can tell you that Lord Justice Mann agreed with both the judgment of Lord Justice North and of Lord Justice Nichols. And turning to Lord Justice Nichols' judgment, which is consistent with that of Lord Justice North, so it starts on page 92 of the bundle. And so you see at the beginning, it's an established principle concerning the assessment of damages that a person who has wrongfully used another's property without causing the latter any pecuniary loss may still be liable to that other for more than nominal damages. In general, he's liable to pay as damages a reasonable sum for the wrongful loss he's made of the other's property. And then he says at D, what's in issue on this appeal is a novel application of this principle, which for convenience I shall call the user principle. And then at the bottom at H, he says that the user principle has been applied to chattels, but the principle is not confined to the physical use of another's property, and he says that it's been applied to intellectual property, to patents. And then if we go to page 94 of the bundle, you see at letter B, in the present case, the council seeks to extend the user principle by applying it to a case of disturbance of market rights. And he says between letters C and D, for some time I was attracted by the analogy between infringement of a patent and infringement of a market right. So he was attracted by that submission. But then he rejects it. And he says at letters F to H that he's concluded that the analogy is unsound and that the application of the user principle in the case of the disturbance of a market right would not accord with the basic principles applicable to that cause of action. A market right confers a monopoly, as does a patent, but the protection which the law affords to the owner of a market right is limited to protecting him against being disturbed in the enjoyment of his right. If an unauthorised market is held without disturbing the lawful market, the owner of the lawful market has no remedy either for damages or otherwise. In such an event, there's no place for an award of damages to be assessed on the user principle. And pausing here, what we can see is that Lord Justice Nichols is looking hard at the nature of the right that's said to be breached. And it's not a right it's not a right which confers exclusive dominion over property. And we say, similar, by analogy, the same is true of the competition rules. And you see at page 95 of the bundle by letter F, in my view, to award damages on the user principle in such a case would lead to the owner of the market right obtaining a greater measure of relief than would be justified by the nature of his right.
Can I just ask you, what's the implication of what's said on bundle 94 at H?
A.
The sentence starting in such an event, there is no place for an award of damages to be assessed on user principle. Thus, for example, if and so long as the owner of the market right is currently not exercising or seeking to exercise his right, is not holding a market at all, he has no cause of action. Is he implying that if he were, then there might be?
There might be pecuniary loss because you're then diverting custom away from his market to the one that's been held by the one that's been held unlawfully.
So in those circumstances, there might be a quantifiable damages.
Yes, conventional loss, not counterfactual loss. So in circumstances where a market's held unlawfully and the claimant is holding a market at the same time and in the same area, then that may divert custom from the claimant's market to the one that's being held unlawfully, and that would be counterfactual loss. But in this case, the judge below had held that there was no loss of that type, and so the question was whether user damages were available, simply to reflect the fact that the right had been infringed. And what both judges are saying that gave judgments is no, because that's not what this right is about. It's not like trespass and detenue and patent infringement.
And would it be right to say that the court's analysis does turn upon its perception of what the right is, as you put it, about?
Yes, exactly. So more than its perception, but just looking objectively.
Its analysis of what it's about, quote.
Of what the right is conferring. What right is this cause of action conferring or protecting? Which again takes us back to the point put to me by Lord Justice Zacaroli, which is what's competition law doing? So competition law is not conferring or protecting a property right such that if you suffer no loss, you can say, but my right to property has been breached, and so I've suffered I deserve an award of user damages. That's not how the competition law rules work when you look at the statute. Now, turning to Devonish, so same bundle, 2 tabs on, tab 8. The main judgment was given by Lady Justice Arden, as she then was, and Lord Justice Tuckey agreed with her. Lord Justice Longmore dissented on the issue that's of importance to us. And the case was a follow-on claim for damages based on a commission decision finding that certain vitamin manufacturers had entered into a cartel. And the question for the court was whether the claimants could seek a restitutionary award of damages or on account of profits. My Lords, I'm just looking at the time, and because we've got a live transcript, I think the request has been made that we have a short break. I don't know if that's something the court is prepared to.
5 minutes, we could have a quick chat. 5 minutes time. We'll take 5 minutes.
Thank you.
We'll come back at 5.
Just to let you guys know, the live stream's still.
Thank you.
Okay.
No, I'm not going to be early because
See you after lunch as well. Yeah.
rise in favour.
Back from our FIFA hydration break. Devonish. So even though
I can tell you
Devonish-
that joke was made outside as well. It's being regularly made at the moment.
Darn. Now, the Devonish, so the point here is that even though it was a case about a restitutionary award, the availability of a restitutionary award in a competition claim, the arguments made by the claimants in favour of the availability of a restitutionary award centred on user damages. And we can go, first of all, to the first instance judgment of Mr Justice Lewison, as he then was. So if we go to page 138, paragraph 77, you can see Mr Leighton based his argument on the basis of Blake and Rootham Park. And then if we go to page 141, paragraph 87, you see how the argument developed. So they were looking at Lord Nicholl's judgment in Blake, in fact. And then you see at 87 how the argument developed. So it says, Lord Nicholl's discussion of the law began with a consideration of remedies for torts. It's true that, as the defendants point out, the torts concerned were all concerned with invasion of proprietary rights. But in the context of Lord Nicholl's speech, that seems to be no more than historical accident. Nevertheless, the defendants argue that I'm precluded by binding authority from applying Lord Nicholl's approach to a claim for damages in tort if the tort is not an invasion of proprietary rights. So you can see that that's how the argument developed. And then if we go on to page 144...
I notice it cites ESSO and NIAD.
It does.
Highly relevant for the fact that I was counsel for the case asking for the remedy with Miss Helen Davis as my junior. But you can move on now.
So highly relevant. You'll know all about that, so I won't need to tell you anything about that case. Let's go on to page 144. So you see at paragraph 99 that the defendants relied on WAS. You see that there. If we go on to page 147, paragraph 108, on the basis of the decisions of the Court of Appeal in WAS and Halifax, I conclude that whatever the law ought to be, it's not yet the law that a restitutionary award is available in all cases of tort. In my judgment, a restitutionary award is not an available remedy in an antitrust case. And so, as the Court of Appeal did, what the judge was doing was proceeding on the basis that user damages were restitutionary in nature. So again, like the Court of Appeal, Mr Justice Lewison was looking at the context in which user damages were available and reasoning from that about the availability of restitutionary awards. And then if you look at...
Is it relevant? I mean, the point I alluded to earlier, that restitution is available when award of damages, more traditional, inadequate in the present case, measure of the restitutionary damages is the same as compensatory damages. So this was, I mean, now we wouldn't ever think about this because everybody knows there's lots of techniques for calculating overcharge in a cartel case.
Yeah.
They're fairly routine. At that point, I think people were worrying about the difficulties of quantification, so they were trying out different alternatives.
They were, exactly.
But were they claiming double recovery, compensation and restitution?
No, they were. The basis for the claim was that they were worried that claiming, for precisely the reasons you give, that a compensatory award might be difficult to calculate. This was before the days of endless expert reports.
This is where we begin to get the broad axe, don't we?
Yes.
So,
and then
but his starting proposition was, well, I understand there's the word moreover, which but the starting proposition was that there was an adequate remedy here.
No, but the reasoning, and this is the point that we make, the reasoning is, so what was being argued was that a restitutionary award was available as a matter of principle. And the reasoning is, no, it's not. And the basis for that is we're bound by WAS to find it's not.
Yeah.
And there are two stages in that reasoning, because of course WAS is a case about user damages. One is that WAS finds that user damages are only available for the proprietary torts and patent infringement. And the second is, well, we think that user damages are restitutionary, so it follows from WAS that restitutionary awards are not available outside those categories either. That's the reasoning. And you can see at 110, under account of profits, the defendant's primary position is that Stoke-on-Trent v WAS precludes an account of profits just as it precludes a restitutionary award. So moving on, so the reasoning, that the argument was all about WAS. And moving on to the Court of Appeal, we can see there that the argument also centred around user damages. So if we start at page 149, this is in the argument. So this is the report of the argument for the claimant. You can see Christopher Vida QC and Andrew Burrows QC, as they then were, for the claimants. And you can see that they are relying on those cases, including WAS. We see that by letter H. And then the respondents, Mr. Hoskins, over the page at 150 F to G, he was saying the compensatory damages are the only form of financial remedy available in tort, and therefore for breach of statutory duty, subject to exceptions recognised only in respect of property rights and based on the user principle, see WAS. So that's the nature of the argument. And the Court of Appeal's judgment starts at page 154 of the bundle. And could I just ask you to read paragraph 2 to yourselves? Because it's quite long. And so just pausing here, so fundamental question, can damages be awarded other than to compensate for loss suffered, so conventional loss? And you can see that the courts have exceptionally awarded damages called user damages. However, this is at E. There's no question in this case of Devonish having been deprived of a proprietary right. That's a right arising from property. And the question is, does WAS bind the court to find that such awards can't be made for purely personal torts? And then if we look at paragraph 4, my essential conclusion on what the judge called the Blake issue, which is the issue you've just seen in paragraph 2, is this. And then you see at D, on that basis, a restitutionary award is available in tort unless it's precluded by the WAS case. In my judgment, it is precluded by the WAS case. And so there are two stages, as I said, to the court's reasoning, two logical stages to the reasoning. The first and critical stage for present purposes is that the Court of Appeal determined that it was bound by WAS to find that no user damages are available outside of the proprietary torts and therefore for breach of competition law. And the second stage is that the court, and it's that first stage that we rely on, and the second stage is that the court held that it followed from that no claims in restitution are available in competition law, and we're not concerned about that in this appeal. And then if we go on to page 161, again you can see at paragraph 25, Mr. Hoskins' argument for the defendants. He submitted that this court is bound by the WAS case to hold that there's no remedy for breach of statutory duty save in damages. And then to take you through Lady Justice Arden's reasoning, if we go on to page 165, you see the heading towards the bottom of the page. First sub-issue, was the judge correct to hold that a restitutionary award cannot be made for a non-proprietary tort? And you have the conclusion on WAS in paragraph 42. The decision of this court in WAS precludes this court from reaching that conclusion, i.e. that a restitutionary award is available. And then at 43, the judge sets out the general principle is that remedies for tort are compensatory damages. And then we can see a discussion at paragraph 46 and onwards about Blake. And the judge finds that the bottom line about Blake is that a restitutionary award is available for breach of contract. And the judge goes on to quote from Lord Nichols' speech in Blake. And if you look at paragraph 51, so the bottom of page 167, Lady Justice Arden is setting out part of Lord Nichols' speech. And you can see there the explanation of user damages for trespass and detention of goods. And you can see that over the page, for example, by letters B onwards. So there's an explanation of user damages, and if we note at H, the court there notes that there's been a move to applying the label of restitution to user damages awards, and we know now that that's wrong. We know that from one step, and it's the court's assumption that user damages were probably restitutionary that led to the second stage of its reasoning. So in other words, we're bound by WAS to find that user damages are not available outside the proprietary torts, therefore restitutionary awards are not. And it's that assumption that underpins the second stage of the reasoning. But as I say, we're concerned with the first stage. Then, if we go to page 171, can I just ask the court to read paragraph 58? Could you read that to yourselves? And then once you've done that, if we can go on to page 175.
What do you say is the relevance from paragraph 58?
So paragraph 58 shows clearly that the court is considering itself bound by the court's judgment in WAS. And that's really the basis for its conclusion in the case, that there's not a restitutionary award of damages that are available. For non-proprietary torts. And then we see, if we go on to page 175, we see the court grapple with WAS directly. So paragraph 71, you can see above that there's the heading, Stoke-on-Trent v WAS. And then you see at the end of 71, the court finds that it's bound by the ratio of either of the reasoned judgments. As I've shown you, those judgments are perfectly consistent. The judgments of Lord Justice Norse and Lord Justice Nichols in WAS are consistent with each other. They're both looking at the circumstances in which user damages were available in the case law, so for the proprietary torts. They both find that the cause of action in that case was not analogous with the proprietary torts. And then if we go over the page to page 177, para 74, the ratio of the judgment of Lord Justice Norse with which Lord Justice Mann agreed is therefore that the user principle ought not to be applied to the infringement of a right to hold a market where no loss had been suffered by the market owner. And my learned friend says in his skeleton argument, well, that's the only ratio. It's a very narrow ratio about a market. But that's not right, and it can't be right. And we see that from paragraph 76. So Norse LJ regarded the underlying rule as a general rule only. It was not an absolute rule, but the exceptions to it are those that he specifies. And the exceptions, as we saw, to the general rule in tort that he identified, the general rule being that damages are to put you in the position that you would have been in if the tort hadn't been committed, is subject to the exceptions that he identified. In other words, trespass and detenue and patent infringement. And we say that this is clear. What Lady Justice Arden is saying is that the ratio of WAS is that user damages are not available outside the limited exceptions specified by Lord Justice Norse in WAS. And if my learned friend were right to say, oh, it's the only ratio in WAS, or the only, that what the Court of Appeal was saying, that the ratio was very narrow in WAS as being limited to markets, well, it wouldn't have gone on to find that restitutionary awards were not available in competition cases if it was treating it as if it was treating the ratio as being narrowly confined to cases of levying unlawful markets. And then at page 178, so over the page, at B to D, so we see, nonetheless, it was an essential part of Norse LJ's reasoning that damages by reference to the benefit obtained by the defendant could only be awarded in those limited situations. And it would, in my judgment, have to be shown that his circumscription of the cases where damages were not assessed on a purely compensatory basis could not stand with Blake's case. And that Lady Justice Arden found that couldn't be said, and you can see that from the end of the paragraph. Blake's case was applied to a breach of contract which did not involve a proprietary right. It can't be said that such a case, it cannot be said that a case that holds that damages assessed on a purely compensatory basis are the only damages available for the torts other than proprietary torts is necessarily overruled, because Blake was a contract case.
You would accept, would you, that the essential reasoning in Devonish
Yes.
is includes that WAS is a case about damages being awarded that are not compensatory but are based on the benefit obtained by the defendant?
Yes, but we know that the damages that were sought in WAS were user damages, and so
it's analysing user damages as damages that are not compensatory but are based upon the benefit obtained by the defendant.
But that's not an essential part of the reasoning in WAS. So going back to the reasoning in WAS and both Lord Justice Norse and Lord Justice Nichols' reasoning, it's true that Lord Justice Norse at some point talks about user damages being, I don't think he uses the word restitutionary, or he may do, but he does make that point. But critically in WAS, both judges are going back to the underlying, the case law to ask themselves when user damages are available. So whether you characterise them as compensatory or not, when are user damages available? They're available for the proprietary torts and for patent infringement.
But it seems, whatever the judges in WAS may have thought, it appears that the Court of Appeal in Devonish did characterise WAS in that way.
Yes, and so I accept that. So, well, no, rather I don't quite accept that. So I accept that the Court of Appeal in Devonish proceeded on the basis that user damages are restitutionary in nature. So, and there are some parts of the Court of Appeal's reasoning here. So you can see that the bit I just showed you in 178b, essential part of Norse's reasoning that damages by reference to the benefit could only be awarded in those limited situations. So my Lord's right that that's what Lady Justice Arden says there. But it's important in our submission not to let that cloud the more fundamental point that WAS was looking at user damages, however they're to be characterised, and that the stepping stone for the Court of Appeal's conclusion about restitutionary, the availability of restitutionary damages, the stepping stone for that was its interpretation of when user damages were available, again, however they're to be characterised. And so we know now that user damages are not restitutionary, and so that second stage of the court's reasoning is now would now fall to be expressed in a different way following one step. But the first essential step is, when are user damages available? And the key point really is not whether they're to be characterised as restitutionary or not, but whether or not damages which are not damages for purely compensatory loss, so not counterfactual damages, that's what they were looking at. So when are damages which are not counterfactual damages available? And you saw that from Mr. Hoskin, the summary of Mr. Hoskin's argument. So we say that the position is therefore that the tribunal in this case was wrong to find that it was not bound by Was and Devonish, and we can see the tribunal's reasoning. If we go back to the core bundle, tab 4, page 57. So paragraph 38 sets out paragraph 76 that we've just looked at of Devonish. And then if we go to paragraph 40, we do not accept this passage when read in conjunction with Was means that compensatory user damages are not available on the facts of this case. And then at 41, as restated in one step, a case is only authority for what it actually decides, which is rather cryptic. So the tribunal doesn't go on to then explain what it takes from that. That's the end of its reasoning in terms of the bindingness, if I can put it that way, of Devonish and Was, which is presumably why the class representative considered it necessary to file a respondent's notice, grappling directly with Was and Devonish. And then you see at paragraph 43, the more general conclusion, it's not possible to extract from these cases or any other cases cited by Meta a principle that user damages are unarguably not available for the statutory tort of breach of the Chapter 2 prohibition in circumstances where a conventional claim to damages is not or may not be available. And that's the error that we say that the CAT made. Now, just turning briefly to my learned friend's skeleton argument on these points, if we go to tab 10, page 120, you can see at paragraph 44 that they say there are 3 reasons why Meta's interpretation of Lady Justice Arden's judgment is wrong. The first argument is the one that I've dealt with in passing, which is that the Court of Appeal in Devonish treated the ratio of Was as being confined to the first sentence of paragraph 74. In other words, just being concerned with markets. And we say that that's obviously a bad point, because if the Court of Appeal had treated the ratio of Was as being confined to the narrow point about rival markets, then it wouldn't have treated it as being binding on it in a competition case. So that's just obviously a bad point. And the second argument is an argument I'm going to come back to about the Gulati case. And essentially the point made there is that that Lady Justice Arden in Gulati recognised a right to user damages, and so she couldn't have been interpreting Was in the way that we say she did, because that would be inconsistent with what she said in Gulati later. And I'm going to show you that although Gulati has been interpreted as being a case on user damages, and it is analogous to user damages, nowhere in that judgment does the court refer to user damages or cite Was or any of these cases. And so that argument is unfounded. And also note that Gulati postdates the judgment in Devonish by some 7 years. So it's not really possible, even in principle, to look at the judgment in Gulati and say, reach conclusions about Lady Justice Arden's judgment in Devonish in the light of a subsequent judgment. And then the third argument is that, we see it paragraph 47, is that the ratio of Devonish is limited to the availability of a restitutionary remedy. And this point makes a reappearance again at paragraph 52 of my learned friend's skeleton argument in support of a different argument that Devonish should not be followed because the court's conclusion about the availability of user damages was not a necessary part of its reasoning. But we say that neither of those arguments is correct because, as I've said, there are two necessary stages to Lady Justice Arden's reasoning. The first is that WAS established that user damages are only available for proprietary torts. And the second is that it follows that restitutionary remedies are only available for proprietary torts and therefore not available in competition claims. And it's the first stage of the reasoning, which is clearly there in Lady Justice Arden's judgment, as I've shown your lordships. And it's obviously a necessary part of the court's reasoning. Otherwise, the court would not have treated WAS as binding at all. We've referred, I don't think I need to turn them up, but we've referred in our own skeleton argument. I'll give you the reference. So paragraph 31 of our own skeletons, that's behind tab 9, page 98, to the key cases as to what's meant by the ratio of a decision. And it's understood broadly to mean the justification for a conclusion that's reached. So any rule expressly or impliedly treated by the judge as a necessary step in reaching their conclusion, having regard to the line of reasoning adopted by them. And we say, looking at that, thinking about what's a necessary step in the court's reasoning, well, a necessary step was the finding that was the conclusion that it was bound by WAS to find that user damages are not available outside the proprietary torts. So we say that this court too is bound by Devonish and WAS.
You say that we are independently bound by WAS, do you?
Yes, I do say that. And
even though it doesn't mention competition law damages and is expressly considering whether one should make an exception, a further exception, and the conclusion of Lord Justice Nichols is wherever precisely the boundaries separating causes of action, etc., has no application to cause of action for disturbance of the market.
yes, but the reason why I say you're independently bound by WAS is, well, there are two reasons. One is that Lord Justice North says these are the exceptions.
Well, they're the established exceptions, and he's considering whether to make further. He expressly says that the question is, these must be closely examined in order to see whether a further exception ought to be made.
Yes, but the basis for both judges deciding that a further exception shouldn't be made is that they focus on the cause of action and they're asking themselves, is this cause of action analogous to the proprietary tort? So you can see, so one of the points made by my learned friend, and they emphasise this, is that Lord Leggett in Lloyd and Google recognises that user damages might be available for misuse of private information for that tort. And they say, aha, that's a tort which is outside the categories in WAS. But as you say, my lord, the court was in WAS considering whether a further exception should be made. And the reason why, and that's the important point, the reason why they considered that a further exception shouldn't be made in the Markets case was that that cause of action did not share the characteristics of the causes of action that had hitherto been recognised as forming the basis for user damages. So it didn't confer dominion or an exclusive right to property.
But if we are in the field where we're looking at a series of cases where they are considering propositions and where we're moving from Blake and Ruton Park, so now we have definitively one step.
Yes.
And we're also looking at exceptions to general rules and whether further exceptions should be added.
Yes.
Doesn't that put us into the realm of developing areas of law where we're injuncted by Lord Brown Wilkinson not to make decisive decisions on those are strikeout cases, but I think you agree that the same principles apply here.
So I think there are two, if I may respectfully suggest, maybe 2 points bound up in your question. The first point is, are you bound to find that the categories are closed? So that's one question. And if you're applying Devonish and Devonish's interpretation of WAS, the court, we would submit, says these are the categories of case in which user damages are available. They're the proprietary torts and infringement of patents. Those, Lady Justice Arden said, those are the exceptions that Lord Justice North identified. Now, it's true that the tort of misuse of private information has sort of been added to the list. And so then you have to ask yourselves, I would respectfully submit, all right, so we're in the position of deciding whether a further, as the court was in WAS, of deciding whether a further exception should be made. So what is the rationale for user damages that's set out in the cases? What's the kind of necessary steps in the court's reasoning in WAS that led it to the conclusion that a further exception should not be made? And the touchstone was that the cause of action confers this right of exclusive property. And so that is a necessary part of the reasoning, and that binds you to find that it's not available in a competition claim, because that's a necessary part of its reasoning. So it's not that you're bound to find that there can never be an exception. So if I were...
It's quite an expansive approach to it, I think. And it might be that at the end of the day, one might say that was the right answer, but whether that's the right approach to take at the strikeout stage.
Well, my lord, I was going to say another point is bound up in your question, which is what's the right approach at a strikeout at a preliminary stage? And to that we say that it would be one thing if the proper interpretation of the law was going to depend on evidence that might emerge at trial. But our argument is that it doesn't. We run a clear-cut argument, which is that when you look at whether you're bound by Devonish or not, I'm going to come on to one step now. When you look at the rationale for user damages in the authorities, including the later authorities, such as one step, it's not consistent, not arguably consistent with that rationale to say that they are available for competition law. And there's nothing that anyone's identified, neither the tribunal nor the class representative, that might come out at trial that can affect that conclusion. So this is a case of grasp the nettle. So we're all here. The alternative is that we have the trial, nothing comes out at trial, because if there were something that could affect the determination of that issue of law, you would bet...
It certainly seems that the interrelationship between the counterfactual proposal and the suggested hypothetical negotiation is opaque at best. And I'm not sure that the injunction to consider these sort of issues in the light of all the facts is necessarily dependent on the view of identifying necessarily that there will be essential facts. It's simply that you just don't know until you've had your trial.
Well, my lord, one would have thought that if you have my submission that this is a matter of legal principle, and we say that we can't think of any facts that might... We've got all of the pleadings, we've got their methodologies, so we've got a lot of information in this case. And the class representative has not identified any facts that are capable of affecting the resolution of the point of principle. So we do put the argument as a point of principle.
I mean, the difference seems to me is that you're basing it very firmly upon two authorities, one of which was where in WAS it was very clearly expressed that the actual decision was that user damages weren't available in relation to wrongfully levying a market. And then a subsequent court of Appeal decision, which appears to have proceeded on a mistaken understanding as to the juridical basis of user damages.
Well,
I know you explain you have your two-step stage, but nevertheless, the Court of Appeal in that case has subsequently been shown to have been proceeding on a mistaken basis in one step. So it's not necessarily the firmest of foundations for saying that there's a completely clear, binding set of precedents which force us to say that this has to be knocked out at the strikeout stage.
Well, my lord, I also put the point in terms of, let's just leave aside Devonish and look at the later authorities, in particular one step. That's what I'm going to turn to now. And it is notable that the Supreme Court did consider WAS in its judgment and didn't overrule it. So it used it as part of the stepping stone to its conclusion. I'm going to show you that. I'm going to go on to show you that now. Yeah. But it is, with respect, necessary to separate out 2 points. The first is the argument on Devonish and WAS, and you may or may not be persuaded by that. We say it's a persuasive argument, my learned friend says not, and that's for you to decide. We have another string to our bow, which is the later authorities, and we are asking you ultimately to determine a pure point of law. So based on the rationale as expressed in all the authorities for user damages, is competition law an arguable case? And
yes, I do understand that, but equally the very clear statements which go back to, I can't remember the names, Bennett and Birmingham case, and then there's the Hughes case in the Court of Appeal, which are very clear that particularly when a judge has exercised a discretion not to strike out on the basis that you have open textured areas of law, that's not something the Court of Appeal should interfere with very readily.
Well, my lord, we see it this way, which is that if we're right on the pure point of law, so if you're persuaded by me when I take you to one step and so on now, that obviously I have to be right on that to win in front of you, but if I'm right on that, then we're in a position where the court will have heard all of the arguments, and we then have the trial. We say that there are no facts that can bear on this point of law, and we're then back in the Court of Appeal having the argument all over again. And so to view it as my learned friend seeks to do, which you've seen in their skeleton argument, they rely on Begum, and they make the points that my lord is putting to me, that it's a case management decision and it should wait until after trial. But we, in our submission, if we're right about the point of principle, and I persuade you of that, that would be a wholly inefficient way to proceed.
And Begum is a Court of Appeal decision which effectively cites previous House of Lords decisions, isn't it?
Yes, but Begum is not. But Begum is. I can take you to Begum, but that's not. It's not. That the point that the key point here is that there are. You've got. You know the law. So the law is that. That very often the courts will consider it appropriate to grasp the nettle and decide an issue of law. They won't be prepared to do that where facts might emerge at trial that has a bearing on it. And we say we're not in that category. No one's pointed to any facts, and so this is a grasp the nettle case. So I want to summarise our submissions on. I'm going to take you to One Step and to Lloyd Google. And I just want to firstly summarise the key submissions we make on those authorities before we turn to them. So we say, first of all, One Step is consistent with WAS and Devonish in finding that user damages are available in tort for the proprietary torts and not more widely. Indeed, as I say, the Supreme Court considered WAS and didn't say that it was wrongly decided or overrule it. Secondly, this disposes, we say, of the class representatives' argument that Devonish should be disapplied because it's inconsistent with subsequent case law. Thirdly, we say, even if this court were not bound by Devonish, it's clear from One Step and Lloyd Google that the class representative has no real prospect of establishing that user damages are available in this competition claim, and the tribunal was wrong to find otherwise. And fourthly, the class representative, as I've said, relies on Lloyd Google and Galati as establishing that user damages are available in the tort of misuse of private information. but this is, on proper analysis, a small incremental addition to the categories of cases in which user damages are available. And critically, the tort of misuse of private information has the same feature as the proprietary torts, namely it specifically protects against expropriation or use of private information without consent, so contrast competition law. Neither misuse of private information nor the proprietary torts are concerned with the terms on which a property owner has agreed that its property can be used, contrast the allegations in this case. So turning to one step, it's in the first volume of authorities behind tab 11. And it was, as the court will be aware, I think in fact my lord gave the judgment at first instance in this case. It was
I think he still bears the scars.
It was a contract case, but the Supreme Court comprehensively reviewed the authorities on user damages more broadly. And can we start with the conclusion in Lord Reed's judgment, which formed the judgment of the majority? So if we go to page 302 of the bundle, paragraph 95. So the foregoing discussion leads to the following conclusions. 1, damages assessed by reference to the value of the use wrongfully made of property, sometimes termed user damages, are readily awarded at common law for the invasion of rights to tangible, movable or immovable property by detenue, conversion or trespass. The rationale of such awards is that the person who makes wrongful use of property, where its use is commercially valuable, prevents the owner from exercising a valuable right to control its use, should therefore compensate him for the loss of the value, of the exercise of that right. He takes something for nothing for which the owner was entitled to require payment. And then at 2, damages are also available on a similar basis for patent infringement and breaches of other intellectual property rights. So, pausing here, the torts that prohibit invasion of rights to property are the torts of trespass, conversion and detenue. And what these torts have in common is that they specifically confer rights not to have your property invaded without consent or used without consent. The same point arises in relation to patent infringement, and competition law does not do that. It does not prohibit the invasion of property rights or confer any exclusive dominion on property. It's directed to something else entirely, which is preventing market distortions as a result of anti-competitive behaviour. And as I've said, nor does competition law prohibit the invasion of property rights on my learned friend's pleaded case, because as I've shown you, the class representative's case is that class members have agreed that Facebook can use their data, but that the terms of that bargain are unfair. So they're not being prevented from exercising a valuable use to control their property. They've agreed that their property can be controlled, and their complaint is about the terms.
Is that much of a distinction, really? We're talking about unfair and exploitative consent, if you like. I agree, consent has been given, that is a difference. But the premise for the remedy that we're working with is that that consent was acquired through exploitative and unfair means.
Well, my lord, it is essential, because the rationale that Lord Reed is pointing to, it is precisely that this is an exception, don't forget, to the general rule that applies in tort. And the rationale that Lord Reed is pointing to is the loss of any right to control use. And that's and the prevention of any ability to require payment or to negotiate a payment. And that's critical. That's there in the rationale. And so that is a critical point. And when one is thinking about the proprietary torts, what they do is specifically confer a right not to have property used without consent. So it's the touchstone, and it is essential in our respectful submission So the law of trespass doesn't say it's a tort to agree to come on someone's land, but on terms which are unfair or exploitative. That's not the tort. It's concerned with these awards of user damages are concerned specifically with that loss of dominion, which is protected by the cause of action. Now, paragraph.
When you say loss of dominion, you mean the fact that no consent has been given?
Yes. So that there's 2 points. One is that the torts themselves confer the property right, and so competition law doesn't do that. So there's no freestanding property right that's being, or cause of action that's being invoked in this case. And the second is that the essence of those torts is that they prevent use of property without consent. And that's the same with the misuse of private information.
So you could have a claim where there was consent, but it's vitiated.
Sorry, you can have consent, but that's vitiated.
Well, there was consent, but say it was procured by fraud. And so your claim would be for wrongful use, even though there may have been a contract if that had been procured by fraud.
Yes, so the question then is, would you have a claim in the tort of conversion, for example, for that? And then, yes, I think if consent is, if there's no consent on proper analysis, so you're not complaining about the terms of an agreement, but there just is no consent, then you're right. Then I think you would have a claim. That's not the pleaded allegation here. So the pleaded allegation here, you've seen it, is that the bargain was unfair. So there's no vitiation.
It doesn't vitiate the consent.
No.
What if, I mean, just to put this in a competition example, what if you've got a dominant entity and the abuse consists of refusing to provide its service to customers unless customers agree to give up or to allow the dominant entity to interfere with their intellectual property, whatever it may be, some other right of
Yeah.
but for which the customer couldn't show it would otherwise have rented that out for profit. That's classic user damages territory, isn't it?
Yes.
You want to show loss.
Well,
But so that wouldn't be excluded. The way you calculate that loss by reference to user damage wouldn't be excluded from competition law just because it's a competition law case, would it?
no, well, we say it would. So we say it would because competition law, user damages are specifically about awards are appropriate where there is a specific right that's protected by the cause of action. And so what the award of user damages is reflecting is that there's this specific right that's protected by the cause of action, and that's been breached. And it may not have resulted in any consequential loss, but the breach of the right in itself, in a normative sense, gives you, it presents a sort of normative loss which is compensated for. And that's not true of competition law. And so in my Lord's example, we would say user damages don't lie in that case because, again, competition law does not confer or protect specifically any property right.
Well, I can understand your answer that it doesn't confer a right to claim damages.
Yes.
But the counterfactual in that case would be one where the customer wasn't required to give up or to allow the dominant entity to interfere with its rights.
Yes.
I thought your answer might be that in that circumstance, you don't really get into a question of claiming user damages at all. You're simply comparing the counterfactual with the actual, and there would have been a payment in the counterfactual.
Yes, exactly. So that's a case of conventional loss, if I'm understanding the example correctly.
It's in a sense, I feel we're like ships passing the night
Yes.
a little bit, because that I can understand as you look to the counterfactual, what would it have been?
Yes.
The customer would not have been required to give up that right.
Yes.
What's the value of that? Well, the customer wouldn't have been able to charge anything for that elsewhere. Nevertheless, you've got to try and find that there is nevertheless something of value being given up. You calculate that by working out what a hypothetical negotiation would have been. So you're using user damages concepts of how you arrive at a value, but in the context of comparing the factual with the counterfactual.
Yeah, so the point that you're putting to me is that if you're comparing, so if in the counterfactual you wouldn't have given something up, so in this case, if there would have been a payment in the counterfactual, for example.
Well, you wouldn't have given it up.
You wouldn't have given it up. Then
Doesn't necessarily mean there would have been a payment.
no, so if you wouldn't have given it up, let me just make sure, let me just see. Yeah, I think so. In that case, our answer, so that's first of all, a different case to the point that's being, the case that's alleged here. So the allegations here, there is consent, so there is a bargain, as they say in terms in their pleading, and they're concerned about the terms of the bargain.
Well, my example was one where, in return for the service, you have to agree to it. So it is the same in that sense.
Yeah. So in that sense, we say you can't get user damages because user damages there are two points of difference between the cases in which user damages are available and the example that you've put to me, my lord. The first is that there is an agreement in this case and in the example you put to me. And so ultimately the competition complaint is that the agreement is unfair and user damages are not available for unfair bargains. So that's not what they're about. So the touchstone, as we've seen, is loss of the right, loss of any right to control property. So it's not about the terms of the bargain. And then the other point of distinction we make...
Sorry, when you say it's not available for unfair bargains, that's because the case law doesn't cover that situation. Is that your word pressing?
Because the rationale for user damages, as consistently explained in the case law, it is about loss of any right to control property. And we see that at paragraph 95.1. That's the rationale throughout the case law consistently. So it's not about, I've agreed that you can use my property, but I don't like the terms. It's about loss of any right. And that...
You emphasise the word any.
Yes, and preventing. So again, prevents the owner, that's what Lord Reed says, so I emphasise the word prevents the owner from exercising a valuable right to control its use. And it's compensating the owner for the loss of the exercise of that right. They've lost the right totally. It's not that they've exercised it, but done so in a way that they say is unfair. That's not the touchstone for user damages. And then we see that reflected in the categories of case where user damages have been held to be available, and they are trespass and detenue and conversion, where there is a total loss of control.
Does that mean on your case, in my example, there would be no compensation payable for the breach of dominance?
Correct.
That's because although they were although as a result of the abuse of dominance, they gave up a right which they wouldn't have given up had there been no abuse of dominance.
Yes.
Because you can't put an economic value on that right, you say there would be no compensation awarded.
My lord, correct. And can I just add to that? So in the same way that in a case, take the tort, for example, of fraudulent misrepresentation. So you could have, as a result of a fraudulent misrepresentation, I hand over part of my property to you, and there's a fraud. Well, I'm entitled to damages if I've lost out, if there's been pecuniary or material loss. But I'm not entitled to damages, to user damages, to reflect the fact that you've had my property. So what we don't see, and then can I just show you, before I just make my round off on this, if we go over the page, because what Lord Reed then does is then considers the basis in which in contract user damages are available, and we see a parallel point. Can I just show you that? So if we go over the page, we can see at 10, negotiating damages. So at 9, where the claimant's interest in the performance of a contract is purely economic, and he can't establish that any economic loss has resulted from its breach, the normal inference is that he hasn't suffered any loss. In that event, he can't be awarded more than nominal damages. And then at 10, negotiating damages can be awarded for breach of contract where the loss suffered by the claimant is appropriately measured by reference to the economic value of the right which has been breached, considered as an asset, and that's important. That may be the position where the breach of contract results in the loss of a valuable asset created or protected by the right which was infringed. So again, that's consistent with the answer, in my respectful submission, I just gave to your lordship in terms of the example that you put to me of a firm in a dominant position exacting property. Generally speaking, if in that situation, in the situation you put to me, we say if there's not material or economic loss, consequential loss, there's no damages. That's consistent with what the Supreme Court has said here, both about the circumstances 95(1) in which user damages are available in tort. They're not available in tort more widely just because your property's been taken as the result of negligence or fraudulent misstatement, for example. And again, for contract...
But if your property's been taken by a fraudulent misstatement, then you would have a claim.
You would have a claim for consequential loss.
For conversion of that property.
You may have a claim for conversion of that property. So you may have a claim, in which case that may not be a good example. You may have a claim for conversion of the property. But outside that situation, so the point I'm trying to make is that both in contract and in tort, there may be circumstances in which something's done to you which results in your property being used or damaged in circumstances where in the counterfactual that would not have happened. That does not per se give you a right to user damages. User damages are a specific exception, and the exception arises where the right itself, the cause of action itself, protects the property right, and where you've given up all control over the property.
Can I just take you back to paragraph 95(1) of one step?
Yes.
Where you emphasise the word any. I'm just looking for the word any. Lord Reed in the second part of 95(1) says the rationale for such awards is the person who makes wrongful use of property where its use is commercially valuable prevents the owner from using a valuable right to control its use.
Yes, he doesn't say any, but we say that...
Is he precluding where the use is less than total?
Yes, because he's saying he takes something for nothing for which the owner was entitled to require payment. So that the points here which make clear that it's total prevention are, number one, the fact that they're available for these proprietary torts, which are all torts which preclude use without consent. That's the first point. Second point is that he uses the word prevent the owner from exercising a valuable right. And the third is taking something for nothing. And so it's not consistent with any of that to say that user damages are available...
You've taken part of an asset and got nothing for that part, and you've got something for nothing.
So if you take... So the key question is whether you could make good a claim in the tort of conversion, for example. So if you take part of an asset and you've got a claim, then yes, you can get user damages. But if you're actually complaining, if you don't have a claim in the tort of conversion, because actually on proper analysis of the facts, you're complaining about the terms that you've agreed for your property to be used, you don't have a claim. That's really the distinction, the touchstone.
But is there that much of a difference between consent being vitiated by fraud and a finding that you've entered into a contract where you've been exploited abusively by the other party?
Well,
I just wonder whether this hasn't actually been investigated in any of the authorities.
sorry, one second. Yeah, so just thinking about the pleaded case here, their counterfactual is not that it's all vitiated. Their counterfactual is that there would have been an arrangement with Facebook, but the terms would have been different. And so that is...
That's the difference between a claim in fraud and a competition law claim. And the question we're looking at is whether or not a competition law claim is so different that it doesn't fall within any of the... It cannot fall within any of the categories for user damages.
Well, there are 2 points, I think, which are logically distinct. The first is whether competition law claims in general are so distinct that you can't get user damages, and we say yes. And the reason we say yes is that there is no competition law doesn't confer any freestanding property rights, or in the same way that the proprietary torts do, or protect.
Forgive me, they don't confer the right.
They protect a right specifically.
Well, the right is already there. The property right exists, and the tort is liability for interfering with that right.
Yes, and it's specifically designed to protect a right that your property shouldn't be interfered with without consent. And so competition law is different because it's about the economic regulation of the market. So it's not, we'll come on to Lloyd Google, but in the way that Lord Leggett found that protection of misuse of private information has the same rationale as the proprietary torts, competition law doesn't. So that's one logically separate point. And the second logically separate point concerns the allegations in this case. And of course, the allegations in this case are not that Meta abused its dominant position by stealing property. It's that there was an agreement between the class and Meta, and the complaint is about the terms of that agreement. And so there are two reasons why this case does not arguably attract an award of user damages. So I was going to take you to the reasoning leading up to this conclusion in one step. Shall I start now and then, or shall we pause now and come back at 2?
Probably better to, unless you want to start for a minute.
Why don't I do it all in one chunk at 2 o'clock?
2 o'clock.